It's 12 o'clock on Tuesday, February the 21st. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Campbell, Davis, Gillespie, Hardaway, Howell, Holsey, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin the day? Seeing one. Leader Lambert.
Thank you, Mr. Chairman. And Mr. Chairman, I make a motion at this time that we sing happy birthday to Mr. Scotty Campbell. It is his birthday today. I'm not going to make y'all sing, but give him a round of applause. Happy birthday, brother.
Yes. Congratulations. Anyone else seeking recognition? We'll go to our Sergeant of Arms, Mr. Tyler Muniz, for his weekly words of wisdom.
Good afternoon, everyone. I'm Tyler Muniz, a proud 45th constituent. I'm here with you for words of wisdom today that are brought to you by the Grand Ole Opry legend, Minnie Pearl. Take the back roads instead of the highways. Have a great day.
Well, thank you so much for that. Well, members, we've got an eventful calendar today. If you will, look at item number 11, House Bill 720. That is going to be rolled 2 weeks. So let's go to item number 1, 1031 by Representative Hurt. You're recognized. There's an amendment, code 4098. Do you wish to proceed with that amendment?
Yes, sir, that's correct.
You're recognized on the amendment.
Thank you, Mr. Chairman, committee. It's an honor to be back in front of you today with House Bill 1031 and Amendment Code 4098. And to get to present to you House Bill 1031 on behalf of Speaker Sexton. If you remember, members, I was in front of you last week. Well, this bill with the amendment will create a disciplinary oversight board, an inmate disciplinary oversight board for the purpose of reviewing and granting denial and removal of inmate sentences for credits for good institutional behavior or satisfactory program performance. This board will be a full-time autonomous inmate disciplinary board that will review inmate sentence credits for good institutional behavior, as well as to determine whether sentence credits previously awarded should be removed due to a major prison infraction. As amended, the board would be composed of 9 members, 3 appointed by the governor, 3 by the Speaker of the Senate, and 3 by the Speaker of the House. The 3 appointing authorities will appoint 1 member from each grand division. Again, as amended, the board will have the discretion to review the removal or awarding of credits as necessary. Currently, there are limited policies regarding the disciplinary boards of each state prison. Creating a statewide oversight disciplinary board will promote public safety while ensuring across the board that each case is treated under the same rules. And to be clear, members of the committee, this legislation is not to prevent reduction in sentence for good behavior. It is to make sure that there is teeth in the disciplinary actions for bad behavior. And with that, Mr. Chairman, I renew my motion.
Thank you. Any questions for the sponsor? Question's been called. Any objection? Seeing none, we're now voting on adding amendment code 4098 on the House Bill 1031. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt. We're back on 1031 as amended.
Mr. Chairman, I renew my motion.
Any questions for the sponsor? Seeing none, we're now voting to send House Bill 1031 on to full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. You move on.
Thank you, Mr. Chair and committee.
Thank you. If you wish to be recorded as a no, you may see the clerk. Next item, House Bill 1186 by Representative Garrett. You are recognized. You will have 3 minutes for comments. I'm just kidding. Take all the time that you need, but seriously.
Thank you, Mr. Chairman. Thank you for that latitude. I appreciate your discretion. Committee, Mr. Chairman, this legislation is brought to me by my juvenile court judge regarding magistrates. It's been a collaborative effort between the juvenile court judges, the magistrate, DCS, the juvenile court attorneys, and the guardian ad litem. They all agree to this particular legislation, so let me tell you what it's about. Currently, as a magistrate judge, which is appointed by the elected juvenile court judge, when they hear a case that's in front of them, they can appeal that case de novo, which is automatically, then it's reheard, tried all over again to the juvenile court judge. If that juvenile court judge makes some sort of reason why they don't like the particular judgment, then it can be appealed automatically to the circuit court judge. So technically, under this particular legislation, a child can be subject to 3 different hearings starting over 3 different times. So it's a long time before this child could potentially be placed. What this legislation does and amends 37-1-107 is that it allows at the magistrate level that is appealed, that it's appealed from an abuse of discretion standpoint instead of starting over. So if there was something that happened at the magistrate level, these are all recording. There is a record of these proceedings. The juvenile court judge can review that matter and either uphold what was done at the magistrate level based upon that he would agree with the decision unless the magistrate did some sort of abuse of discretion, and then the judge could rehear that case just like it was under the current statute. So that's what this legislation does. I'll be happy to take any questions. The purpose of this is to streamline that process so a juvenile's case is adjudicated quicker instead of taking so long to get to adjudication. Mr. Chairman, I'll be happy to take any questions.
Well, thank you for your explanation. Members, do we have any questions for the sponsor? Representative Johnson.
Thank you. So what you're talking about is they're looking at this. If they find something, then they will refer it back, correct? Or in that appeal.
Do you mind if I have a clarification?
Sure.
When you say from the magistrate's,
Right.
when it's in the magistrate's hands and then it's appealed to the judge's court,
Right.
to the juvenile
Correct.
court judge, then what was your question so I can make sure I respond correctly?
They still have the ability, when something was done incorrectly, to rehear that. Is that, I think that's what you told me, what you told us.
Yes, absolutely. That's the case.
Okay. And in the case that that didn't happen, then what would be the next step?
In case that it wasn't reheard, is that what you mean?
In the case that there was not a problem under the original.
If it is appealed from the magistrate to the juvenile court judge and the juvenile court judge agreed with the magistrate's findings, then that becomes the ruling of the juvenile court judge.
Can you give me an idea of like the timeline of how this will change that? You say it streamlines it, I get that. I'm curious about what sort of difference and change it can have on that time.
It's a very, very, very good question. The time frame between each appeal is in the statute, so don't quote me to the exact timeline, but according to the court's dockets, my hope is you got a 30 or 60 days that you can potentially cut off before there's an adjudication of what's going to happen to the juvenile if there's a placement issue. So it's going to, because you're not going to a whole nother court. Some cases the court has to hear within 10 days, within 6 days, depending upon the issues that are being tried before the court, but some aren't. And so this is the idea of trying to streamline that because, unfortunately, you will have some parents that know the process, that know that they can go to the magistrate and basically get free discovery. And then if they don't like the outcome, not because it had any basis in law, not because the magistrate was wrong or right, they're just doing it to get free discovery, and they automatically get to appeal to the judge. And you've got a whole nother preparation time. The witness has got to be available. So it cuts down, we hope, on a lot of that issues at the magistrate level because most of the time, not all the time, but most of the time the magistrate is correct. So the judge can look at that decision and make that decision instead of it just being automatically starts over no matter what the magistrate decided. And Representative Johnson, there are in Knox County, you have 8 of these magistrates that would hopefully help them adjudicate some of these some of these cases.
Thank you. Any other questions for the sponsor? Seeing none. We're now voting to send House Bill 1186 on the full criminal. All those in favor say aye. Those opposed, ayes prevail. You move on. Thank you.
Thank you, Mr. Chairman and committee.
Item number 3, House Bill 1280 by Representative Kiesling. You are recognized.
Thank you, Chairman.
Welcome back.
Well, thank you very much. It's good to be back.
We're glad to have you.
Been a long journey, so it's great to be back and be with you and the members today. House Bill 1280 simply changes the punishment for the charge of aggravated stalking of our senior citizens from a Class A misdemeanor to a Class E felony. Now, currently, the actions against our elderly are only considered a Class A misdemeanor punishable by a maximum sentence of 1129 with $2,500 fine. But again, that's the maximum. Judge can go below that as well. A Class E felony, however, requires a mandatory sentence of 1129 in prison and can carry up to 6 years with a $3,000 fine. This was anyway. The Sheriff's Association, is my understanding that the Sheriff's Association is in supporting this legislation, and if there should be any further questions or clarifications, I'll have to submit to the legal for any questions probably concerning that, since I'm not schooled in all the legal beagles that there is. But anyway, with that, Mr. Chairman, I'll entertain any questions that members may have.
Well, thank you for that explanation. We do have someone on the list here to testify on this. So members, without objection, we'll go out of session. Hear from a gentleman, Mr. Archie.
Would you want him over there, Chairman?
Anywhere that you would like to have him.
Well, wherever you want.
This will be fine right here.
That'll be just fine. If you will, introduce yourself for the record. You'll have 3 minutes for comments.
Okay, my name is Richard Archie, and I have been running this bill in the General Assembly now for about 5 years. We actually passed this in 2016, but the fiscal note on it was so great that it was put behind the budget and it was not funded. Ran it again in 2017. We got the fiscal note down to 70,000, but it failed in the Senate at that time. I bring this bill because of the treatment that my mother received. In 1978, she was voted by our peers as the Tennessee Teacher of the Year, and that year from the governor received an award as an outstanding Tennessean. She taught her whole entire life. She moved from Tennessee to Texas, came back to Tennessee, and then when she retired from teaching, again, she started teaching at the McKenzie School for Immigrants to teach those children how to speak English. She loved to teach and she loved people. At the age of 84, she had some people move in next door to her that were criminals. They tried to adversely possess her property. They ran a barbed wire fence across it in the dark of night, and when my father tried to push it down with his tractor, he was accosted in his yard. It took us 4 years to resolve this in the courts because the sheriff could do nothing about it, because the only thing he had to charge these people with was a Class A misdemeanor. I have talked to a number of sheriffs across the state, and they assure me that if they had this tool in their box, that what they can do is go back to these miscreants that are hurting our elderly, and they can appraise them of the fact that they're not going to be charged with just a misdemeanor, but a Class C felony. We did this same protection for our youth under the age of 18 in 2005, and at that time, under the Bill Public Act in 2005, it was Chapter 482, the fiscal note on it was $590,000, or a little more than that, and then a reduction of the cost by locals. But the fiscal note this year is just $59,000 because the sheriffs have said that they won't be incarcerating as many people if they can assure them that they're going to spend serious time for taking these actions. My conjecture is that 18-year-old people can run from danger. 84-year-old people, not so much. And the 80-year-olds have not spent as much time in tax dollars for the state as the 84-year-olds have as well. So I'm asking that you look at this, and like I said, this General Assembly has passed this bill twice before in the House. So I'll entertain any questions.
Thank you. Any questions for our guest? Well, seeing none, thank you for being here. We'll go back into session. Representative Kiesling, you are
Yes, sir. I'll renew.
recognized.
I'll renew.
Anyone, question has been called. Any objection? Seeing none, we're now voting to send House Bill 1280 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on. Thank you.
Thank you, Mr. Chairman and members.
Item number 4, House Bill 1385 by Representative Reagan. You are recognized.
Thank you, Mr. Chair. Ladies and gentlemen of the committee, I will put you at rest. I'm going to have to roll this bill, but before I do, a few comments are in order. The phrase intent to go armed is in our statute. I have reviewed 522 court cases on this particular phrase. In all but 2 of them, the terminology used in conjunction with this was in the commission of a dangerous felony. The phraseology that I put in there, because I couldn't find a definition in our code of dangerous felony, was infamous crime. I could find that in its equivalent. However, the reason that I am rolling this, quite frankly, is the departments have come to me, TBI and Department of Safety, and told me that they're content with removing the phrase entirely. So I am going to go back to the well and draft an amendment that does that. With your indulgence, I'd like to roll this 1 week, sir.
Well, thank you very much. Without objection, roll House Bill 1385, 1 week.
Thank you.
And so is Littleton. Do I have to roll all of these? I'm back on. Well, members, let's go to item number 16. If you will, jump with me there to item number 16, House Bill 115 by Representative Moody. You are recognized. There is an amendment, and I'll give you just a second to get your notes set up, but there's an amendment, code 3680.
Correct.
Do you wish to proceed with that amendment?
Yes, I do, please.
All right. You are recognized on your amendment.
Thank you so much. This program is something from the Secretary of State's office. This office already operates the Safe at Home Address Confidentiality Program that helps victims of domestic violence shield their home addresses from their abusers. So this bill will create the Tennessee Business Against Trafficking Program as a companion to that Safe at Home Address program. So what this will do is a voluntary program, and that businesses can join, and the businesses would agree to participate in periodic training, education, and public awareness campaigns to help identify potential victims of human trafficking and let people know where to report concerns. Participating businesses will receive recognition from the Secretary of State's office. This has been done in some other states that are very similar. This bill will establish the parameters of the program and provide rulemaking authority to the Secretary of State's office to further build out the program using the best practices of the current and to be created similar programs in other states. So with that, any questions?
Well, thank you so much. Members, do we have any questions for the sponsor of this bill on the amendment? Seeing none, we are going to vote now on the amendment, code 3680. Those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 115 as amended. Any questions? Seeing none, we're now voting to send House Bill 115 as amended on to full criminal law. Those in favor say aye. Those opposed, the ayes prevail. You move on to
Thank
full
you,
criminal.
committee.
Thank you. Members, we'll go back to item number 6, House Bill 1245 by Representative Powers. You are recognized. There is an amendment code 3707. Is that one that you wish to proceed with?
Yes, Mr. Chairman, please.
You are recognized on the amendment.
Did you say 3707? Is that correct?
Yes, sir.
Okay. So you want me to talk about the amendment or the bill as amended?
The amendment, please, sir.
Okay. The amendment actually makes the bill, if that matters.
I'm sorry?
The amendment makes the bill.
Okay, well, just have at it.
Okay. Sorry, I lost a few notes here on the way, and got to pull them up on my iPad. Okay, and the reason I'm bringing this bill, it's a death penalty bill, and the reason I am bringing it is because of one thing is about the length of time that death row prisoners stay on death row. So we've looked at everything trying to be constitutional that would help speed up that process, and one thing that we can do is to give them another option, and so that's what my bill does. So for the 22 prisoners put to death in 2019, the average time was 22 years that they stayed on death row. Far largest time between that since 1970. As of January the 1st, 2020, 1,344 death row prisoners, more than half of them 20 years or more. 22 crime survey administered said reported held for capital punishment, that people supported it by 55%. Judge Sonia Sotomayor, one of our Supreme Court judges, argued in Arthur versus Dunn, in addition to being near instant, death by shooting may also be comparatively painless. This is currently used, the firing squad is currently used in Utah, Arkansas, Oklahoma, and recently passed in South Carolina. Several years ago, a blow to the capital punishment, with the problems that we've had, first of all, in the state of Tennessee, in lethal injection and in the electric chair. So that's why we want to give them another choice. South Carolina's governor signed a bill into law in 2021. Death row inmates must choose whether to be executed by electric chair or firing squad if the lethal drugs are unavailable. And that's what this bill does. It gives them another option. And a survey of death row prisoners actually said that they would prefer to die by firing squad. That was the preferable way of ending their life. So with that, I will take any kind of questions, but what we want to do is give them another choice, and hopefully some people will choose that way, and we won't have the problems that we're dealing with lethal injections and with electric chair, and it will speed up the process for many of them. So with that, Mr. Chairman, I'll take any questions.
Thank you. Any questions for the sponsor on the amendment? Representative Johnson.
Thank you, Mr. Chairman. So everything we know about the electric chair being considered cruel and unusual punishment, not being an effective way, being incredibly painful, is something that a civil society would not actually use. We're putting that on the table again, as well as firing squad, which has been considered similar in many cases. Because we want to kill people faster? Is that what you said?
Not really that. We want to give them a choice. And so we have so many people that are sitting. Let me give you an example. I had one person in my district sit on death row for 33 years. He and a 17-year-old went up and knocked on the door after they saw the father leaving the house. They went in, raped and tortured and killed the mother and 15-year-old daughter, cut them each over 200 times. That guy sat on death row for 33 years. We had to pass a bill several years ago that would allow other family members to come in because the father that was one of the victims in that had already died. So we don't need prisoners sitting on death row for 33 years in the state of Tennessee or anywhere for that matter, and this is just giving them another option. The firing squad was argued about being quick, humane, and reliable. So that's what we want to give them a choice of doing. And if they want to go ahead and take the firing squad, then hopefully that's going to speed up the process where people won't be sitting on death row that long.
It was argued. That mean there was another side to that argument. And I understand that.
There is to all of them. I'm sorry.
Yes, exactly. and we should think about that. But I would like to say that in this country, we are a civil society. And there's certainly other ways to go about this. And we can cite a whole lot of just really heinous crimes that there's no question that people have committed really horrifying crimes. But what we tend to see with folks on death row and folks with the death penalty, typically they are poor. Typically they are higher numbers of racial issues there. And we know that approximately 4% of folks on death row are most likely innocent. Certainly since 73, 200 people, almost 200 people have been found to be innocent. And this rush to their death, I just disagree. I just don't think that we should be, that's not really a choice in my view.
Okay. And this is completely optional. This is completely up to them if they want to choose this method. If they don't, they can sit on death row. But if they decide to choose that, or if they want to sit on death row and continue to appeal, if they feel like they're innocent, they probably wouldn't want to choose the firing squad. But it is another option, and it's completely up to the death row inmate whether or not they want to choose this.
I guess that I would say that some imagine being falsely accused and being in prison for something you didn't do might lead you to feeling so hopeless that you might want to go ahead and do that. Maybe you think that there's no hope.
If that were true, then you could go ahead and choose the electric chair now anyway. So that's another option. If they wanted to do that, if they felt that hopeless, they could go ahead and choose to not do any more appeals and go ahead and do the electric chair or do lethal injection. So they still have that option to do that now too, yeah. So we're just adding another option is all we're doing.
Chairman Holsey.
Thank you, Mr. Chairman. I understand there's 4 other states that have this, is that correct?
That's correct.
Okay. Has this ever been pushed up to the court system as being cruel and inhumane? It hasn't, has it?
It has not.
That's what I thought. Okay.
Thank you. Any other questions for the sponsor on the amendment? Any objection to the question? Seeing none, we're voting to add Amendment Code 3707 on the House Bill 1245. Those in favor say aye. Aye. Those opposed? No. The ayes prevail. You adopt. Any questions for the sponsor on 1245 as amended? Seeing none, we're now voting to send House Bill 1245 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? Ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman. Thank you, committee.
If you will, go with me to item number 14. Don't go anywhere there, please.
Okay.
Item 14, House Bill 702, be ran by Representative Powers. You are recognized. There is Amendment Code 3990. Motion on amendment. You are recognized on the amendment.
Thank you, Mr. Chairman, committee. Yes, we all know what fentanyl, the problems we've had that. We know the open borders, and we know that there's been enough fentanyl that's come across our borders to kill every American here. And the only way we can try to hopefully deter from some of the fentanyl poisoning and some of the people that have been poisoned in our state is to make our bill much tougher. So this bill actually does that. I'll just give you an example. Somebody in my county, on October the 4th, 2020, Kent Blackwell died from acute fentanyl toxicity on the restroom floor of a local Pizza Hut in Campbell County. The fentanyl that Mr. Blackwell ingested was in a pill that he had acquired from his best friend. So it wasn't like somebody was trying to kill him. It wasn't intentional. It was a best friend that sold him a pill. And recently, last year, as you all know, here even in Nashville, had a girl that was a valedictorian for her class. She goes to New Orleans, splits a pill with a girl down there. They thought it was a Xanax, but it was laced with fentanyl. She died. The other girl went intensive care, but I think she ended up living. But it's like that. We see this every day. 300 people a day in our country are dying of fentanyl poisoning. And if we had a plane crash, a large plane crash every day, everybody would be outraged. And I'm outraged that 300 people are dying every day in our country. Over 100,000 last year from fentanyl. So what this what this bill does is put the drug on the same structure as cocaine, meth, and other things that we're actually trying to put it on the same. I'm sorry. We went back. I need to look at something. Okay, yeah, we're going from a Class C felony to a Class B felony for any amount that's 0.5 grams, which is all it takes to kill you, but less than 15 grams. Right now, the current law is 15 grams. And for any amount involved in that, it's going to be a Class B felony. So that's what this bill does to the drug. It moves it up from a Class C to a Class B felony. And hopefully that will deter some people from selling this drug and pushing it on their friends and through our communities.
Thank you. Question's been called on the amendment. Any objection? Seeing none, we're now all righty. Question was withdrawn. Representative Davis.
Thank you so much for bringing this forward. You're very correct that this is a crisis and this is absolutely needed. So my question has to do with if some of those folks that are not adjudicated right now, so I noticed that the bill takes effect July 1. Is there any way that we can have it take immediate effect in order to really ensure that people understand that the seriousness of what this drug does and how it's killing people?
Mr. Chairman. Well, thank you, and I wish we could. I don't think there's any way, and we have some lawyers up there too, but I don't think there's any way to go ahead and put it in immediate effect. I think we're going to have to give some kind of notice of what we're doing and when it'll take effect, and that'll give us a few months to notify the public and what's coming down the pike. I don't think there's any way to do it immediately. I wish we could.
I will add that it'll give opportunity for law enforcement and prosecutors to be able to prepare for this, because it is going to be a lot more legwork on their side once we make this jump. Any other questions for the sponsor on the amendment? Seeing none, we're now voting to add Amendment Code 3990 on House Bill 702. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We're on House Bill 702 as amended. Any questions for the sponsor? Seeing none, we're now voting to send House Bill 702 on the full criminal as amended. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Thank you.
Thank you, Mr. Chairman. Thank you, committee.
Item number 5, House Bill 1359 by Representative Farmer. Motion. You are recognized.
Thank you, Mr. Chair, committee members. Apologize, had to step out of Chair Lady Littleton's committee there. I'm trying to make this quick. Members, what this bill does, it allows for charges to be abated if someone were to pass away, die, while the charges are pending. That's what it does.
Any questions for the sponsor? Seeing none, we're now voting to send House Bill 1359 on the full criminal. All those in favor say aye. Aye. Those opposed? Ayes prevail. You move on.
All right, thanks so much.
Thank you. Item number 7, House Bill 482 by Representative Boyd. Motion. You're recognized. There's an amendment code 4078
Thank you, Mr. Chairman. That is the code I'm showing as well.
All right, do you have a motion? Is there a second? On the amendment. You are recognized on the amendment.
Thank you, Mr. Chairman and committee. This is the same bill that I came with last week, and what this seeks to do is create a Class C felony for someone who commits the offense of critical infrastructure vandalism, interrupts or interferes with critical infrastructure or its operation, destroys or injures critical infrastructure, and it tightens it up a little bit. We discovered last week that it was sort of broadly defined and included agriculture, so we've tightened that up to just include what I described. And after doing this, I actually visited with my district attorney, who is here today. We had a conversation, and he sort of explained to me that district attorneys, I mean, they have enough common sense and latitude to know when someone is spray painting graffiti on the side of a substation and it needs to be just traditional vandalism versus someone who brings down an entire electrical grid or seeks to sabotage a gas pipeline or poison water that goes to a municipality. And folks, those crimes really are in a different league. And so what this seeks to do is create a Class C felony that can be prosecuted under this statute at the discretion of the district attorney. Mr. Chairman, I'll take any questions.
Well, thank you for that. Any questions for the sponsor on the amendment? Seeing none, we're now voting to Amendment Code 4078 on the House Bill 482. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We're on House Bill 482 as amended. Any questions for the sponsor? Seeing none, we're now voting to send House Bill 482 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on. Thank you.
Thank you, Mr. Chairman and committee.
Item number 8, House Bill 556 by Representative Littleton. You are recognized.
Thank you, Mr. Chairman and committee. Sorry, I'm late. I was in my committee. This bill cleans up current statute to accurately reflect that the Vulnerable Abuse Registry is administered by the Health Facilities Commission rather than the Health Department of Health, adds a time frame of 90-day calendar for clerks of court to submit paperwork to the Health Facilities Commission to place an individual on the abuse registry, and it strengthens the current process of the abuse registry. I'll welcome any questions.
Thank you. Any questions for the sponsor on the bill? Seeing none, we're now voting to send House Bill 556 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman and committee.
Item number 9, House Bill 557 by Representative Littleton. You are recognized. There is 2 amendments.
I want to just move forward with 4264, please.
Amendment Code 4264. You are recognized on that amendment.
Thank you, Mr. Chairman. So this, with the amendment, proposed legislation will expand the age of admissibility for a forensic interview for children 17 and under, will expand the cases in which a forensic interview may be admitted to severe physical abuse or witness to acts of violence, clarifies that the recording is admissible at any stage of a criminal proceeding, still allows for cross-examination of the child during trial, and adds alternative qualifications a forensic interviewer may meet in order for a recording of an interview conducted by the forensic interviewer to be considered admissible. I welcome any questions.
Thank you. Does the amendment make the bill?
It does make the bill.
Thank you. Are there any questions for the sponsor on the amendment? Representative Johnson.
Thank you, Mr. Chair. You said that it made some other changes. Could you name what those are near the very end of what you stated? When it came to the interviews.
This would allow the CACs to recruit graduates directly from college, maintain all of the qualifications otherwise mentioned in the statute, and require that the new forensic interviewer to work under supervision of an experienced forensic interviewer and get qualified applicants for open positions.
Okay, thank you.
Any other questions on the amendment? We do have testimony here. So without objection, we'll go out of session to hear from Ben Rabin. Going once, going twice. We will go back into session. We are on the amendment. Motion or question has been called on the amendment. Any objection? Seeing none, we're now voting to adopt Amendment Code 4264 on the House Bill 557. Those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We're on House Bill 557 now as amended. Any questions or comments? Seeing none, we're voting to send House Bill 557 as amended to full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman and committee.
Item number 10, House Joint Resolution 19 by Representative Littleton. There's a motion and a second. You are recognized.
Thank you, Mr. Chairman. This HJR urges the United States Congress to enact legislation to make state child abuse registries public record. DCS already has it, but they're not allowed to make it public. And this just urges Congress to allow that.
Well, thank you. Any questions for the sponsor? Seeing none. We're voting on sending House Joint Resolution 19 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman and committee.
Item number 12, House Bill 659 by Representative Martin. You are recognized.
The East Tennessee State University, but lives in our community. And he was a member of the Tennessee Intercollegiate State Legislature, and I hope Levi's here somewhere. I don't see him to testify. But basically, this bill was brought about because of issues that were brought during that conversations this summer. And so the question was asked is by his friends is when someone has been assaulted as a young person and they go to court later in life, should they not be judged, or should not the situation be judged by at the time that the offense happened and not at the age that the person is when they're finally coming forward? Because many victims of sexual abuse as children or whatever maybe find it difficult to come forward until later on. And so the bill has no physical impact. It seeks to clarify in the current code what is already interpreted by the Tennessee courts in many cases. And the bill helps shift the negative stigma around victims of rape and sexual assault and to prevent a person's ability to receive the justice that they're due. This bill clarifies that each of the above offenses that are listed in Title 39, 13, Part 5, that the victim's age must fall within the approved age range at the time of the offense, not at the time of the individual that is come forward.
Thank you for that explanation. Leader Lambert.
Thank you, Mr. Chairman, and I apologize I didn't have an opportunity to reach out beforehand. So I absolutely applaud your efforts in this. I think it is something that we definitely should proceed on. The problem I have is I can't identify how this changes current law, because what you've described is what does occur. But I am confident there are probably some areas here that maybe there could be an improvement in the law. In order to kind of have those conversations, would you mind rolling this about 2 weeks so we can just examine, talk to our district attorneys, talk to some of the lawyers out there, and just see how we can maybe cinch this up so that it does match with exactly what your goals are?
Leader Lambert, I'd be proud to do that, to roll that for 2 weeks. If I may respond, Chairman Doggett, one of the things that has come to the attention is that often the courts are interpreting this, but it's not in the statutory that we should make the judgment for the time that the offense happened. Mm-hmm. So even though that is what is being done often in judgment, it's not in the law, and hence the reason for the language. Yeah. Thank you. And young Levi is here.
Well, you have someone here on the list, Levi, to testify. Do you? Yes, sir.
Yes, sir, Mr. Chairman, and I hate to belabor the committee and the time. If we could, I'd make a motion at this time to roll it 2 weeks. Sponsor said he's fine with that, and then let's just have an opportunity for all those meetings to occur in between time, and then we can hear all the testimony next time. But Mr. Chairman, I'm comfortable with whatever you're comfortable with, obviously, but I should have made that specific motion a while ago to just make a motion, roll this 2 weeks. Sponsor sounds like he's fine with it, so I do make that motion now.
Well, that is a proper motion. Any objection to that? Seeing none, we'll roll 2 weeks.
All right, our next bill is House Bill 31 by Chairman Doggett.
Motion.
Motion and second. Chairman, you're recognized.
Thank you, Mr. Chairman. House Bill 31 adds to the offense of rape to offenses in which a defendant is not eligible for probation under the Tennessee Criminal Sentencing Reform Act of 1989.
All right, you've heard an explanation. Are there questions for the sponsor? No questions. Well, I'm going to call the question on the bill then. We're voting on House Bill 31. All those in favor say aye. Aye. All opposed, no. The ayes have it. It passes on to criminal full. Next is House Bill 15.
Motion.
Second. It's House Bill 704. You have a motion and a second. Chairman, you're recognized.
Thank you very much, Mr. Chairman. House Bill 704. We seek to address the Medicaid Fraud Control Unit, which would be housed within the TBI. The bill would accomplish two goals. First is lining up state authority with current federal authority, specifically allowing investigation of misappropriation of funds or property in healthcare facilities and expanding investigations of abuse, neglect, or financial exploitation of Medicaid recipients to any setting. Secondly, we would make it clear that the director of the TBI would have the authority to create new divisions within the Bureau to allow for more efficient operations. This Medicaid Fraud Control Unit, by statute currently under Criminal Investigation Division of the TBI, it is large enough and specialized enough to warrant being on its own division. Therefore, investigators would continue to have the same authorities and powers as those in other divisions, and I have members of the Tennessee Bureau of Investigation here if there are any questions more specific to this bill that I can't answer.
Okay, Chairman. I can't anticipate if there are questions from the TBI, but we'll go out of session. If they will come forward, and if you have anything to add to the explanation of the bill, or if your deodorant's not working, we can go right back in session. If you state your name, please, for the record.
Patrick Powell, TBI. Chairman Doggett kind of hit the nail on the head. Just kind of do those two things. We'd appreciate any support that the committee can give to it.
Okay, are there any questions from the committee? All right, no questions. All right, we're going back in session. Thank you, sir, for that exercise. I appreciate it. Are there any questions for the sponsor before we vote on the bill?
Previous question.
I'm sorry. Yes, sir, Chairman.
Thank you, Mr. Chairman. Just to clarify, help me understand, what we're doing is creating a separate investigative division within the TBI that's autonomous? Did I understand that or misunderstand that?
it's already within, there's a division already within the TBI, but this is making them their own unit, separate and distinct unit within the TBI. But we could go back out of session and hear from Mr. Powell, who could answer that.
That's up to the chairman.
Chairman Howe, go ahead.
I just, then who would this new agency report to?
It stays within the TBI. They report to the director.
Okay. And this, I'm sorry, Mr. Chairman.
Go ahead.
if I may. And this agency then would focus primarily on medical fraud?
Yes, sir.
Got it. Thank you.
Any other questions for the sponsor of the bill? All right, we are voting on House Bill 704. All those in favor say aye. Aye. All opposed, no. The ayes have it. Passes on to criminal full. Is indeed.
Thank you for that fine exhibition of chairmanship there, Mr. Chairman Holsey. Item number 17, House Bill 114 by Representative Russell. You are recognized.
Thank you, Mr. Chairman and committee. House Bill 114 allows the court to sentence a defendant convicted of 2 or more criminal offenses to consecutive sentences with the defendant is sentenced for criminal offenses involving more than one victim, and the court finds a separate consecutive sentence for each offense is the interest of justice. I've got the Attorney General or the district attorneys present to answer any questions about this.
Well, thank you. We do have someone on the list, so without objection, we will go out of session. Hear from Mr. Jason Lawson. If you would, introduce yourself for the record, who you represent, and you'll have 3 minutes for comments.
Yes, sir. My name is Jason Lawson. I'm the district attorney for the 15th Judicial District. I appreciate the committee hearing me this afternoon. This bill will give the judge discretion to run multiple sentences against multiple victims consecutively and not at the same time, if the judge finds that it's in the interest of justice to do so. Right now, our statute has 8 grounds in which a judge has to find one of those 8 grounds in order to trigger the judge's discretion to run those sentences consecutively. None of those 8 grounds cover multiple crimes against multiple victims. So right now under Tennessee law, if a person decides to commit a second crime against a second victim, our victims are in the position of hoping that that second crime is going to fall into one of the other categories that are on the list. For instance, like the person was on probation or is being sentenced for criminal contempt, or it's a sex abuse crime against an elderly person or something along those nature. This is a very a more generic language. It's basically a tool that the judge has that he can utilize whenever he feels that it is appropriate. If a person decides to commit a second crime against a second victim, and the judge feels that in the interest of justice, he should have 2 sentences that were running consecutive, and instead of those sentences running at the same time, the judge has the ability to do that.
Thank you for your testimony. Any questions for our guest, Representative Johnson?
Thank you, Mr. Chair. I'm just curious, would this be hard to define what I'm talking about, but a separate incident, like it could be 2 victims in the same sort of commission of the crime, but are we talking about that, or are we talking about something that happened at a different point in time, maybe a week later, 2 weeks later, a year later?
Yeah, the language of the bill does not designate that. It puts it in the judge's hands so the judge can, if he determines in the interest of justice that that's necessary. For instance, if a person goes up and commits a homicide and then there's a person there who's an innocent witness and they turn and kill that second person in the same criminal episode, this could be something the judge would say the second victim should not have to endure that their sentence is going to run at the exact same time as the first victim, and not a single day of additional sentence would be added for killing the second person. So it could be the same criminal episode. Or if a person decides to go out and commit a crime, this day and then turn around and commit one 2 days from now and then turn around and commit another 2 days from now, this encompasses all situations in which there are multiple crimes against multiple victims. And the only requirements are, and it's complete discretion on the part of a judge. The statute already says the judge may order consecutive sentences if these grounds apply, and then this one adds the additional requirement on top of that if the judge, in the interest of justice, determines that it would serve the interest of justice to run those sentences consecutively.
Thank you.
Any other questions for our guest? See, now, General, which part of the state are you from?
Clark Board mentioned a few moments ago, but I'm Wilson, Macon, Smith, Jackson, and Trousdale. Already had Representative Kiesling and Representative Boards in front of you this afternoon from my district.
Well, very good. Well, you're well represented.
Thank you.
Yes, sir. Well, thank you very much. We'll go back into session. Representative Russell, you're recognized.
That's all I got, Mr. Chairman. I renew my motion.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 114 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Item number 18, House Bill 373 by Vice Chair Gillespie.
Thank you, Mr. Chairman. So what this
You'll need a motion in a second.
Oh, sorry.
Vice Chair. Now you're recognized, Vice Chairman.
Thank you, Mr. Chairman. So what this says is it's basically filling in a loophole from the Truth in Sentencing bill that we passed last year. Right now, it's possible for someone to commit aggravated assault with a firearm and, just the victim has a good surgeon, and therefore, through this loophole, it is possible for that person not to serve any time inside a jail cell. And I don't think that's right. And what's going on in Memphis right now, and across the state to an extent, with the issue of aggravated assaults is just beyond reproach. And I think this is definitely a fix in the right direction. I think, just because you are a bad aim or you happen to have a good doctor on staff at the hospital the victim goes to shouldn't be an indicator as to whether or not that person should go to jail or not. And I understand there's a bit of a fiscal note here, but I just ask y'all to let's have that conversation another day and try to get some help to my constituents and some people across the state. And with that, I renew my motion.
Thank you. Any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. Sorry, I just need some clarification. I'm a little, could you be more specific other than a good doctor on your example here?
Yes, I shoot you and I miss. That person right now can get paroled or even through some loopholes that currently exist, not get sentenced to prison. They could get prohibition instead. And I don't think just because you're a bad shot, the rules shouldn't apply to you.
Any other questions for our sponsor? Seeing none. Now voting to send House Bill 373 on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move on to full criminal. Item number 19, House Bill 5 by Vice Chairman Gillespie. Motion. You are recognized. There's Amendment Code 3917.
Yes, that is correct.
Need a motion.
Second.
And you're recognized on the amendment. Question on the amendment. Would you withdraw that, please? Thank you. You're recognized on the amendment.
Thank you, Mr. Chairman. This amendment makes the bill. What it does is it's just removing a portion of the previous bill that would put convicted felons of aggravated kidnapping and rape on the sexual offenders list. It's removing that part of the bill and leaving the rest intact, making it a range 2 minimum for aggravated kidnapping and rape. For that.
Okay. Thank you. Any questions for the sponsor on the amendment? Seeing none, we're now voting to adopt Amendment Code 3917 on the House Bill 5. All those in favor say aye. Aye. Those opposed, the ayes prevail. If you wish to be recorded as no, see the clerk. We are now on House Bill 5 as amended. You're recognized. Representative Gillespie.
Thank you, Mr. Chairman. As I stated, what this does is it's increasing the actual time served for people convicted of aggravated kidnapping and aggravated rape. These are especially heinous offenses, and right now there are people that are committing them that are not seeing the appropriate amount of time and rehabilitation inside of prison. And what this will do is make sure that those people that are convicted of aggravated rape and aggravated kidnapping, and especially aggravated kidnapping, spend the time in prison that jury and that judge sentences them to. And with that, I renew my motion.
Thank you. Any questions for the sponsor on the bill as amended? Representative Hardaway.
Thank you, Chairman. And I just want to be clear, is it 100% of the sentence, or is there another percentage?
Thank you, Mr. Chairman. Representative, so what it does is it would be for 100% of these offenses. There's a sentencing guideline, range 1, range 2, range 3 for each different felony level. And this would just simply move these 3 offenses to that range 2 for the Class A and Class B felonies that they represent currently.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 5 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move on to full criminal. Item number 20, House Bill 104 by Representative Parkinson. Motion. Second. You are recognized.
Thank you, Mr. Chair, and thank you, committee. Can I get a roll call vote on this, please?
Roll call vote has been requested.
Thank you, Mr. Chair. Eliza Fletcher was a runner and mother of 2. She was a 34-year-old teacher here in Tennessee. She was out on a morning run, as was her regular routine, not knowing that she would never return home to see her family, friends, students, and coworkers again. She died of a gunshot wound to the back of her head and blunt force trauma. Her partially decomposed body was found near a vacant house in Memphis on September 5th. First, let us continue to remember the family of Eliza Fletcher and all other victims of sexual assault who are yet to receive justice in our state due to the backlog or the time it takes to test sexual assault rape kits in our state. In 2014, I ran legislation to have rape kits tested within 30 days. The bill was sidelined in Budget Committee as it was put behind the budget where it died. 7 years later, a convicted felon by the name of Cleotha Abston was accused of rape by a very courageous woman by the name of Alicia Franklin. Almost a year later, the same convicted felon, Cleotha Abston, was accused and charged for the kidnapping and murder of Eliza Fletcher. It was during the murder investigation of Eliza Fletcher, almost 1 year to the date of the rape kit DNA result, almost 1 year to the date that the rape kit DNA results were returned by Tennessee Bureau of Investigation with a positive DNA match to Cleotha Abston for the rape of Alicia Franklin. Now, why is this significant? This is significant because had we passed the legislation to ensure that rape kits were tested by TBI and returned within 30 days back in 2014, the positive hit to Alicia Franklin's rape case would have come back in 30 days. Cleotha Abston would have possibly been incarcerated on rape charges, and Eliza Fletcher would have finished her run. We as leaders in our state are partially to blame for the death of Eliza Fletcher and the delay in justice to all rape survivors because in 2014, we had the ability and the financial wherewithal to ensure that rape kits were turned around within 30 days, but we did not have the will to make it a priority, nor the will to make the safety of our citizens a priority. We owe this to the family of Eliza Fletcher, Alicia Franklin, and every single person who has been a victim in the past and those who are unfortunate enough to become victims in the future. Our passage of this legislation will ensure that a psychological deterrent signal is sent to those would-be rapists in our state, that we are not going to drag our feet in bringing them to justice swiftly, to remove them from our streets, and to protect our women and children from these horrific actors. House Bill 104 will ensure that rape kits are tested within 30 days of receiving them, and within 45 days of passing this bill, TBI will submit to the governor, the attorney general, both speakers, and the attorney general's conference a plan to eliminate any backlog of rape kits in the possession of the Bureau for more than 30 days. And lastly, if erroneous DNA has been submitted by law enforcement, TBI will send written confirmation that the DNA has been expunged. With that, Mr. Chair, committee, I move passage.
Thank you for that. First on my list is Leader Lamberth.
Thank you, Mr. Chairman. Representative Parkinson, thank you for bringing the bill. I was going to file almost the exact same bill, and I remembered that you had filed this bill before. I supported it at that time and fully support it now. I mean, it is a very intricate issue to get enough scientists at the TBI and enough space at the TBI and enough funds, but it is a must, not an option for us to do so. And so we should be supporting our law enforcement partners in every way that we can so that there are fewer victims and survivors of violent crime out there. So I appreciate you bringing the bill. And again, would have filed it literally myself had it drafted. And I had heard tell that you were working on this particular issue. And just out of respect for you, I know you've worked on this issue for years. I didn't file mine, fully support yours. Thank you, sir.
Thank you, Leader Lamberth. And had you filed yours, I would have supported yours wholeheartedly.
Chairman Hulsey.
Thank you. I understand exactly what you're saying completely. TBI, I think, is doing the best they can do with what they've got. The governor's, in his budget, is expanding the number of lab technicians, and it takes a long time to train those people and get them put in the position. Not too long ago, it took 48 weeks to get DNA back. And so my only problem with the bill is there's other evidence too that's just as important as this, like on homicide cases with DNA and the length of time it takes to process that and get a report back. I think TBI is doing better. I don't know if you're successful in saying 30 days and you've got to have the results back when you've got all the evidence they're dealing with before them. That 48 weeks has been reduced, I think, to about 38 weeks now for DNA evidence. But two questions is, I don't know how you get it done without increasing the staff to work on it. And the second question is, what happens if they don't get it done in 30 days?
Thank you, Mr. Chair. We're not going to put TBI in timeout, I can tell you that. But we're going to make our best effort to ensure that these rape victims and survivors get the justice that they need. So I think it's incumbent upon us to put forth our best effort to make sure that this happens.
Thank you. Do you advocate setting aside other evidence that they're working on to put these first? Is that what you're looking at?
Thank you, Mr. Chair. I advocate us giving TBI the resources that they need to ensure that these rape kits get turned around in 30 days. Or tested in 30 days, rather. I'm sorry.
Thank you. Any other questions for the sponsor? Seeing none. A roll call vote was requested, so Madam Clerk, please take the vote.
Representative Campbell? Aye. Campbell votes aye. Representative Davis? Aye. Davis votes aye. Representative Gillespie? Aye. Gillespie votes aye. Representative Hardaway? Aye. Hardaway votes aye. Representative Howell? Aye. Howell votes aye. Representative Hulsey?
No.
Hulsey votes no. Representative Johnson? Aye. Johnson votes aye. Representative Lamberth?
Aye.
Lamberth votes aye. Representative Moody? Aye. Moody votes aye. Representative Russell? Aye. Russell votes aye. Representative Sherrill?
No.
Sherrill votes no. Chairman Doggett?
Yes.
Doggett votes aye. Chairman Doggett, you have 10 ayes and 2 noes.
All right. Thank you very much. The bill passes on the full.
Thank you, Mr. Chair, and thank you so much, committee.
Item number 21, House Bill 546 by Representative Harris. You are recognized. There is an amendment code 3935. You wish to proceed with that amendment?
Yes, Chairman.
All right, you're recognized on the amendment.
Thank you, committee, and to the chairman. So this amendment just adjusts the original amendment by 90 days, back from 180 to 90 days. Currently, in current form, whenever an individual gets out of prison after serving their time for a felony, they immediately start having to pay their fines, fees, and penalties, which they absolutely should be paying. But this would delay it by 90 days, only beginning the first quarter of next year by 90 days, so that way it allows that individual time to go and get a job to be able to pay those fines and fees.
Thank you. Any questions for the sponsor on the amendment? Seeing none, we're now voting to adopt Amendment Code 3935 on the House Bill 546. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt on House Bill 546 as amended. Leader Lambert.
Thank you, Mr. Chairman. On the bill, I mean, I know you've researched this and looked into it, but I mean, if this person's on probation or parole, they already work with them on a payment plan. It's already required in the statutes that they work with them on that. And I know I've expressed my concerns to you privately, but I do just want to say it publicly on the record that, I mean, there isn't even a range here on how long somebody would have served. So, I mean, if somebody served 6 months and they had a lengthy probationary period afterwards, why would it make any sense not to at least allow the clerk and the probation officer and the court to immediately start working with that person from the get-go? Because that helps them get those fines and fees paid off quicker. But I mean, right now, they have to give them a reasonable payment plan. They have to work with them. So why would we do this kind of what I would consider a bit of an extreme step?
Thank you so much. So one of the concerns that came from the judges and the court system was that what happens is oftentimes, even with the payment plan, they require them to come back to court, and the person will say, oh, I still haven't gotten a job. I still haven't gotten a job yet. And so all they're doing is rolling it another 30, 60 more days out for them to come back and say it again. And so a lot of the courts and judges would find it as a relief that they wouldn't have to start until 90 days out, just because right now it looks like they're just going to roll it anyway.
But I guess that goes exactly to my point. I mean, they have the authority to do that now. A judge can say, well, sir, you don't have to come back for another 90 days. I mean, the judges can handle all this now. Again, your efforts here are laudable, but I think this is a meat cleaver approach to a situation that probably needs more of a scalpel. But that's just my humble opinion.
Thank you, Leader.
Any other questions for the sponsor? I do have a question. What happens if the person fails to come back and pay after this 90 days? If they finish their term of imprisonment and their sentence and they decide that they're going to leave state and not come back?
Well, the fees and fines, this doesn't change that they still owe the fees and fines. It's still the same process. Even if they currently do the same thing right now and they decide in 90 days in they want to leave the state and go away, there's still a process that they have to follow. This does not change any of that. All it does is delay the process by 90 days to allow people the opportunity to get back on their feet, to be able to afford and pay those fees and fines.
All right, thank you. Any other questions for the sponsor? Seeing none. We're now voting to send House Bill 546 to full criminal, or excuse me, I'm sorry. Yes, sir, Representative.
Before we vote, is it possible to offer a roll motion? Give the sponsor time to work with legal line.
Representative Hardaway, can you clarify what motion that you're wanting to make? I may have misunderstood. Couldn't fully hear what you were saying there. I'm sorry.
Mr. Chairman, are we on the amendment or the bill?
We are on the bill as amended.
Okay, I was asking if you hadn't finished your statement, if it's possible that we could do a one-week roll and allow the sponsor to get with Lita Lambert. It's a motion.
So you have a motion to roll 1 week?
Yes.
Leader Lamberth.
Thank you, Mr. Chairman. Since my name was called, I'd make a motion to amend that to last calendar.
Okay, so the original motion was to roll 1 week, and the motion was made to roll it to the last calendar, which makes this now open to debate. Okay. All those in favor of the amended motion to roll to the last calendar, say aye. Aye. Those opposed, the ayes prevail. So we've amended the motion. Now we're voting on the amended motion to roll to last calendar. All those in favor say aye. Aye. All those opposed, the ayes prevail. House Bill 546 as amended will be rolled to the last calendar.
Thank you, committee.
Item number 22, House Bill 277 by Representative McKenzie. You are recognized.
Thank you, Mr. Chair. This is a pretty simple bill. It just calls for a TASER study, just to take a look at the sentencing guidelines that's for those nonviolent, for example, a simple marijuana possession that probably had I will say, had a stiffer sentence in the 80s, 90s, early 2000s, as it does today, just to have TASER take a look at that study.
Thank you for that explanation. Any questions or comments for the sponsor, Chairman Hulsey?
Thank you. I don't see anything wrong with the study at all or the request. Probably take some time to get through that. I would like to, Chairman, make a motion to send this to summer study and really do an in-depth look at it.
That's a proper motion has been seconded. Representative?
If I might comment, this notion was actually embraced by the governor's office at the time, and he was planning a large McKinsey organization type of comprehensive criminal justice, but that never happened. So this is a good carve out for that. Just to have TASER take a look at it. We're only talking about making a data-driven decision. So this is great data for us to consider.
Well, thank you. The motion on the table at the time is before us is a summer study motion. It has been seconded. All those in favor of sending House Bill 277 to summer study say aye. Aye. Those opposed, the ayes prevail. House Bill 277 been referred to summer study. Item number 23, House Bill 986 by Representative Beck.
Thank you, Mr. Chairman.
You are recognized.
I'm thrilled to be back in the confines of the committee that I love so much.
I will say we have missed you.
Well, I appreciate that. Thank you, and I've missed you guys. Today I come with a constituent-driven bill. Just want to read you a short article real quick from the Tennessean of May of 2022. The kindergarten teacher started getting suspicious as soon as she heard the man on the sidewalk mumble he wanted to cut across the playground. The teacher, Rachel Davis, told him no, he would have to go through the front door if he wanted to get in for any reason. Suspiciously, she turned to the anxious when the man disappeared for a minute, came back and started walking around in circles on the sunny May 11th morning. The guy got within 20 feet away from her 32 kindergartners outside the recess at Inglewood Elementary School in Nashville. You get a fishy feeling, said Davis. To play it safe, I said, let's line up, kids, so we can all go in. The moment the other teacher opened the door, the man hopped the fence, raced toward the door. Davis said, I need to get inside. He shouted, I need to get inside, I need to get inside. Davis, terrified, planted her 5'5", 130-pound body in front of the door, saying loudly, no, sir, you cannot come through this door. I need you to leave the playground. And a scuffle ensued. Ms. Davis received a broken elbow and other injuries from this horrific situation. The man was later charged with a Class A misdemeanor for assault. What this would do is that if you're a trespasser and you get into a assault on a teacher or other school officials, that we would upgrade this to a Class A misdemeanor to a Class E felony for the punishment of assault by intentionally, knowingly, or recklessly causing bodily injury to another if the offense occurs while the defendant was trespassing on school grounds. So in order to qualify, you would have to be a trespasser, and this gentleman obviously was. He was told not to come on to school grounds, and you would also have to cause an assault. So if you're just a regular parent and for some reason you get into it with a teacher, you couldn't, you're on the grounds as a invited guest, so you wouldn't be able to use, this is only for someone who is not to be on school grounds. And with that, I stand to take questions, Mr. Chairman.
Well, thank you very much. Any questions for our sponsor, Representative Towns?
Thank you, Mr. Chairman. Bill, this bill is, this actually happened, right?
This actually happened,
in Nashville?
Representative Towns, in Nashville at Inglewood Elementary on Riverside Drive.
Rather frightening. Did they ever find out what his intentions were?
They did not.
Did he get jail time at all?
Yes, as a misdemeanor.
At a lower level?
Correct.
Thank you for the bill.
Thank you.
I do have one brief question. Any school employee this would be applicable to, if you were a custodian, cafeteria worker, teacher's aide, guidance counselor, that's anyone that would be there as a condition of their employment on the school grounds, and they were assaulted while they were in the commission of their work, their duties, that this would apply for that enhancement.
That's correct, if the person who assaults is a trespasser.
Perfect. Thank you. Any other questions for our sponsor? Question has been called. Any objection? Seeing none, we're going to vote now to send House Bill 986 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman. Thank you, committee. Wonderful to be with you.
All right, members, we have 5 minutes left in committee, roughly. We will take up item number 24, House Bill 22 by Representative Chisholm.
Thank you, Mr. Chairman and committee.
All right, you are recognized on House Bill 22.
Thank you, Mr. Chairman and committee. I've brought to you House Bill 22. This bill requires the law enforcement officer conducting a formal interview or interrogation of a minor taken into custody for suspicion or commission of a delinquent act to make a video or audio recording of the interview or interrogation. It also provides an exception for a situation in which the officer in good faith believed in the interview or interrogation was being recorded and there was a technical issue. So it gives an exception for if there's a technical issue where they could not make that recording. I also say that this bill has passed the Senate 30-0, and I stand by for questioning.
Thank you for that explanation. Leader Lambert.
Thank you, Mr. Chairman. I know we're short on time. Just a quick question to legal if we can go out of session for a second.
All right, we're going to go without objection, go out of session. Hear from Legal Services.
Mr. Chairman.
Oh, you're recognized.
Thank you, Mr. Chairman. I didn't want to speak without being recognized. So.
Well, I thought you'd already asked your question in my head. I was waiting on Legal Services to give you a response. I'm sorry.
We're just on the same wavelength today. It's all good. Just a quick question. I know I was talking to the sponsor of this legislation about this, but if an interview is done and evidence is obtained that is in violation of this statute, would that trigger the exclusionary rule and that evidence be excluded from being considered?
Michelle Fogarty, Legal Services. The bill doesn't speak to that, but if you put it into law and require law enforcement to record them and then they don't and none of the exception doesn't apply, then yes, the exclusionary rule would apply because it would be done in violation of state law.
Thank you. That's all I have, Mr. Chairman.
Any other questions for Legal Services while we're out of session? Okay, Chairman Halsey.
Thank you. The definition for unruly, is that confined to status offenses, or can that involve criminal offenses as well, and is that in this bill delineated?
That is not delineated in this bill. Unruly is, let me see. An unruly child is one who is habitually and without justification truant from school, habitually disobedient to the reasonable and lawful commands of their parents or guardians, or commits an offense that is applicable only to a child, or they are a runaway. But this bill doesn't specifically delineate between delinquent and unruly children.
So this law would apply to any agency that's investigating unruly or status offenses, which I don't know that that's necessary.
Yeah, it applies to, I'm sorry, it applies to delinquent and unruly conduct. Yeah.
Thank you.
Any other questions for Legal Services? Seeing none, we're going to go back into session. We're back on House Bill 22. Any questions or comments for the sponsor? Seeing none, we're now voting to send House Bill 22 on to full criminal. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. The bill moves on to full criminal. If you wish to be recorded as a no, please see the clerk. Members, that brings us to the end of our calendar for today. Due to time constraints, all remaining bills will be rolled to next week's calendar. You're now adjourned.